Good morning, everyone, and thank you for joining us for this webinar. Today, we unpack the 2025 Code of Good Practice on dismissals that became effective for September 2025. It replaces the previous Schedule 8 code and the separate operational requirements code, consolidating the guidelines on misconduct, incapacity, including incompatibility, which is quite an important development, and poor performance, probation, and retrenchments. So the code is intentionally flexible. It recognizes that fairness looks different in small and large enterprises. Small employers are not expected to run HR-style formalities, and simple, oral, streamlined processes are acceptable if they remain fair. Larger employers should have policies and possibly more structured and transparent procedures. Across context, the code emphasizes employment justice, mutual respect, corrective discipline, and meaningful consultation. And today we'll unpack what that means practically. I'm handing over to my partner, Imran, who will take us through some of the procedural fairness requirements, as well as consistency in sanctions.
Right. Good morning. Thank you, Annelie. The question with regards to procedural fairness, I just want to start off by tracing some of the history on the new code and its implementation just at a very high level. So we've operated under the Schedule 8 Code of Good Practice since 1995. That's 30 years until it was repealed and the new code came into effect, as Andy has said, on the 4th of September 2025. So that's 30 years of Schedule 8 Code of Good Practice. The new code has been in the making, I would say, since at least 2006, and that would have been in the seminal decision, which we're all familiar with, in Everil Elizabeth, and that was, almost 20 years ago. So the wheels of justice, as it were, kind of turned quite slowly. So for 20 years, the courts have essentially been pushing for informality in internal workplace processes quite strongly since Everil Elizabeth. But I would say that this concept of a move away from a decriminalized process to a less formal and what could be called an informal internal workplace process probably goes back to about 1997 in that famous decision of Morapani and Gilbey's distillers. And that was a case we may remember where the dispute arose before Justice Landman at the time on an urgent application in the Labour Court to interdict internal disciplinary proceedings. And there was a debate about whether the court should be intervening in internal processes or request for further particulars on charges in an internal inquiry and the like. And the court took a firm position way back in 1997. That was 2 years after Schedule 8 to kind of say, but the process is meant to be an informal process. This is not what Schedule 8 was designed for, because the intent was to move away from the criminal style processes which had existed under the rubric of the unfair labor practices in the 1956 legislation. So that's some of the history. If we fast forward from 97 to 2006 in Everil Elizabeth, we then get to another important judgment in Trustees for National Bioinformatics Trust. And this was also a decision of Justice Van Niekerk in the Labour Court as he was then in 2009. And I just want to read certain passages from his judgment that kind of then influence where the new code comes from. So what he says in the judgment, and I'm quoting from it, he says the following: the employer dismissed Jacobson after a protracted disciplinary inquiry into allegations of misconduct. The inquiry, i.e. that's the internal disciplinary inquiry, was the antithesis of what is contemplated by Schedule 8 of the Code of Good Practice under the Labour Relations Act. The inquiry was chaired by a senior counsel. Both the employer and Jacobson were represented by legal practitioners. The inquiry was conducted over a period of months, resulting in a transcript excluding the documentary evidence, which exceeded 5,000 pages, and a finding by the chairperson of the inquiry comprising some 450 pages. The judgment then goes on to say that the LRA introduces, this was in 2009, the court is talking about the 1995 Act. It says that the 1995 Act introduced a simple, quick, cheap, and informal approach to the adjudication of internal processes. The alternative process is intended to bring about the expeditious resolution of labor disputes. The court then goes on to say that the applicant, that was that the employer chose to ignore the informal workplace procedures prescribed by Schedule 8 of by the Code of Good Practice, and to conduct a disciplinary inquiry at great expense in a form that would make any criminal court proud. I've previously had occasion to comment on the profitable cottage industry that has developed from the application of unnecessarily complex workplace disciplinary procedures, and how inimical the actions of some practitioners, consultants, so-called trade unions and employers' organizations, and various other carpetbaggers who populate the industry are in relation to the objectives underlying the Labour Relations Act. And I end the quote there. So this gives an indication of what the position has been of the Labour Court, 2006, 2009, which then gets us to where we are to the new code. So whilst the processes in the CCMA, and we'll remember this at least in the early 2000s across to, I would say, at least maybe 2016, 2017, and maybe there was a change around 2018, is that when you got to the CCMA, the requirement was almost very checklist approached against the Code of Good Practice, Schedule 8, on procedural compliance. If there wasn't tick box processes complied with, an employer would then be taken over, would be wrapped over the knuckles, and there would be a finding of procedural unfairness. So there was a disconnect between what the Labour Court was pushing for and what was happening on the ground at the CCMA. So the new Code of Good Practice must be seen in that history, that what the courts wanted was to ensure that the intention of the 1995 legislation is now, without any doubt, in the form of clearer relaxations for employers to ensure fair dismissal, and now provides that expressly that that there must be a decriminalized process and one that may be informal. So I just want to discuss some stats on dismissal disputes, which I managed to pull up. This only relates to CCMA dismissal disputes and does not account for bargaining councils and does not deal with any private arbitrations. The CCMA stats show that for its financial year 2022 and 2023, that 53% of all their referrals across the country were dismissal disputes. That came to 97,560 dismissal disputes. In the 2023-2024 financial year, it was a 52% referral rate, with numbers kind of sitting in the same region at 97,882 dismissal disputes. So the number of dismissal disputes that get to the CCMA is in excess of 50% of the entire workload of just the CCMA. So what does the code now actually do in relation to procedure? The law hasn't changed. The position is clear that a dismissal is fair if it is for a reason which is fair and follows a fair procedure. So onto the question of fair procedure, Annalie made the introductory comment that grounds exist for dismissal for conduct, capacity, operational requirements. We've all known that. What the code now specifically makes mention of is incompatibility, and incompatibility is a form of dismissal in relation to capacity. That's a good development in our law. It's one that has set in a myriad of case law, but now sits in the new code, which is welcome in relation to its clarity. So the new code provides that the purpose of a fair procedure is to ensure a genuine dialogue and an opportunity for reflection, and I use this term broadly, an opportunity for reflection by both employer and employee before any decision is taken by the employer with regards to a sanction. And a fair procedure means that the employee has been given an adequate and reasonable opportunity to respond to the allegations. That's the golden thread of procedural fairness. An employee is given an adequate and a reasonable opportunity, understanding what the issues are, to respond to the allegations. So an investigation or an inquiry does not have to be formal. Its nature should be appropriate to the circumstances. So it depends on the nature of the complaint against the employee or employees. That will determine the level of sophistication and formality to be utilized for the investigation or inquiry, including the type of allegation and the nature and size of the employer. And size of employer is an important factor, as Annalie has mentioned. So I just want to pause for a moment on this question of an investigation or inquiry. We'll know that under Schedule 8, that the reference was that there be an investigation or an inquiry. there's somewhat been, over the years, a debate as to whether or not the investigation constitutes the inquiry, or whether there's a separate process of investigation before an inquiry. What the new code refers to is an investigation or an inquiry, meaning that once an investigation is conducted, which means that there must be an emphasis on a proper investigation that justifies any form of conduct or any form of performance-related issues, which necessitates some form of sanction being instituted against the employee, that there may be a hearing at that stage, and that investigation may morph into an inquiry, or itself be the inquiry that results in a termination of employment. So the nature and the circumstances of the issue before the employer is important to be determined, because that to a large extent will determine the form of process to be utilized. So to conclude on this point, the summary, I guess, would be the following: that the code requires all employers to act in a fair, transparent and a consultative process before dismissing an employee. That's got to be tailored to the circumstances and the nature of the employer. And employees must be informed of the issues and allowed a reasonable opportunity to respond before a decision is made. So what this does is that it takes away all of these issues with regards to requests for further particulars, laborious processes in relation to lengthy documents and evidence being placed before a chairperson of an inquiry and initiate a proceeding before a chairperson of an inquiry, etc., etc. So depending on the circumstances of a matter, a more informal process may be utilized, which may then do away with the processes as we've known them over the last 30 years. Discipline against a trade union representative, there is no change in the code. That should not be instituted without first informing and consulting the trade union. So the position under Schedule 8 has remained intact. With regards to industrial action and discipline during the course of strike action, the Labour Appeal Court position in Steve Spa Blackheath remains entrenched in the new code. There's no changes in that regard, and the processes as we've known them remain intact under the new code. I just want to move to the form of inquiry and what a hearing actually means. So traditionally, it's always been understood that a disciplinary inquiry or a performance inquiry or a hearing would mean the convening of people physically, or in certain circumstances, at least we've seen a lot of this post the COVID era in virtual hearings. A hearing does not always have to be conducted in that manner. A hearing can be conducted by exchange of written representations. Now, what's meant by that? It's meant that you don't need somebody to present oral evidence. You don't need to come to a formal inquiry that's convened. The charges or the complaints against the employee is produced and set out in writing. The evidence, the investigation report is made available to the employee during the course of the written representations, and the employee is given an opportunity to respond to that. And a third party who's not been involved in that process is then given, who becomes the chairperson, will then make a determination on those written representations. Now, written representations is also a hearing, and it's a form of hearing that has found its way into our law for a long time, has found its way into our employment law for a long time, and in fact goes back to a decision in Unguchane versus Rivia.com, which was a CDH matter in 2010. So the law that you may use that sort of a process has been entrenched, or has been confirmed by the Labour Appeal Court way back since 2010. And we've been using, since the Rivia.com judgment, in appropriate circumstances, written representations as opposed to formal convening of inquiries, quite often since 2010, depending on the circumstances of a matter. If I can just close off on this issue of written representations and just make mention of one recent example. We were approached by a company a couple of months ago in relation to a new report to a CEO who the CEO was having tremendous difficulty in managing, both from a conduct perspective and in respect of a number of capacity issues. The matter was swirling internally for 6 months before it had come to us. And it was one of these employees who pushed the boundaries to the point where there was just kind of not enough to take action against the employee. It was one of those star employees. When the matter had come to us, we consulted on the matter, we looked at the documents, and the advice that we'd given to the client was to run what I've referred to you on this review.com process is a written representations, was not to convene an inquiry, because this employee would have used the platform of a formal inquiry to run this process forever in a day, which would then have avoided or would have protracted the internal processes. From the date that we consulted, formulated the complaints, convened the inquiry in the form of written representations, and it appointed a chairperson who was a counsel from the Johannesburg Bar who considered those representations, the entire process had taken 2.5 weeks. So within a period of 2.5 weeks, we'd put up the complaints, gave the employee the opportunity to respond to the complaints, and thereafter an outcome was issued, all within 2.5 weeks. The dismissal was then effected, and from the date of dismissal, it had taken 2 months for that matter to be resolved in the CCMA. The matter was eventually settled on the first day of arbitration, but it had taken 2 months from the date of dismissal for settlement. So the point that I want to make is that the usage of an informal process in a matter such as that, which had been appropriate, had been properly investigated, called for taking the fight outside of the workplace, taking the fight to the CCMA and having the matter resolved, all within a period of 3.5, 4 months. And there's a growing number of employers who are using this informal process and who have successfully done so over the last number of years. So what are the takeaway points in relation to procedure? It would be the following. Know that you can use an informal process suitable to the circumstances. Not every inquiry has to be an inquiry that is convened in a formal setting. So review disciplinary codes and procedures. Look at collective agreements where amendments need to be effected to those should be done, and employment contracts as well. So to receive the full rewards of the new code of good practice, review disciplinary codes, collective agreements, and employment contracts that deal with issues relating to discipline. I'm going to then turn to the question of inconsistency. I'm going to be short on that and then pass along to Thabang, who will then pick up on the further topics. Inconsistency is now specifically mentioned in the new code, and it can be summarized as follows: 3 points. That dismissal should be applied consistently. Nothing new. We've always known that to be the law. What the new code does is that it takes a number of labor court authorities and it codifies it in the code. So it accepts that dismissal should be applied consistently for similar misconduct. Secondly, the exception is that inconsistency does not automatically make a dismissal unfair if the situation is intolerable. So there's an exception which comes out of a number of cases that is now written into the code in relation to the application of inconsistency. And finally, inconsistency is a factor in determining fairness by the CCMA, but is not the only factor. So where employees have historically relied upon inconsistency as a basis to avoid dismissal, in the CCMA, the code is now clear that that's not the position. So consistency is a factor in determining fairness, but not the only factor. So I'll conclude on that point in relation to inconsistency and then pass on thanks to Thabang.
Thank you, Imran. I'll be dealing with 2 topics. The first one will be in the topic of incompatibility, and the second topic that I'll be looking at will be the issue of poor performance. But let's start with incompatibility. What the code has done, similar to what Imran was dealing with inconsistency, it has now basically recognized incompatibility as a form of incapacity, bringing the code in line with the case law and basically codifying what case law has been saying all along. In practice, what this means for employers, where you are first faced with an instance where there is a potential incompatibility, is that employers will first pin down the behavior causing the friction, try to identify the relationships that are affected by the friction, suggest possible fixes, which could include things like counseling, mediation, or realignment, and give an employee a fair chance to respond and improve. It's only if the situation cannot be repaired that a dismissal becomes an option. Now, as I stated earlier on, that this basically codifies what has been the principles from case law. One can think of, for example, the case of Zita Kali Singh versus Van Dijk, which is a Labour Appeals Court judgment of 2020, which is a landmark judgment that confirms incompatibility as a form of incapacity. The court's rationale in Zita Kali's was that incompatibility directly impairs the capacity to do the job and the viability of the employment relationship as a result. The Labour Appeal Court reasoned that it can, in principle, be a substantively fair reason for dismissal when the employee is unable to sustain the workplace relationships reasonably required for the role. The court tied in that particular decision, it tied this to the LRA's capacity ground and not misconduct. So that's basically one of the leading judgments that basically recognized incompatibility as a form of incapacity. Now, the same sentiment was earlier expressed in the judgment of Jabari versus Telkom, which is a 2006 Labour Court judgment, which basically says that incompatibility is a species of incapacity. And in that particular judgment, the rationale behind the court's decision was that treating incompatibility as a form of incapacity was it was basically that incompatibility is a form of incapacity, and when you do not treat it that way, you basically do not recognize that what is at stake is the employee's inability to integrate. It's not a capable refusal. It's not that the employee does not want to be compatible, but they are unable to be harmonious insofar as interpersonal relationships are concerned with their colleagues. And as a result of that, that is why one needs to view it as a form of incapacity as opposed to misconduct. The very same sentiment was expressed in a very earlier judgment going back to 1992 in Wright versus St. Mary's Hospital, where in that particular judgment, and it's probably one of the first major articulation, where it was articulated that incompatibility is not misconduct, but relates to an employee's inability to maintain harmonious relationships, and the procedural framework was echoed. It's the same framework that was echoed later on in the Zeta and Telkom cases. So basically, that's what the court is doing. But one should be careful to say, in instances where the employee willfully is creating a disharmony, friction in the workplace, then that might not qualify as incapacity. And one has to consider an earlier judgment of 2020 in Werribee versus Productivity SA and another. It's a Labour Court judgment. And in that particular judgment, it basically stated that where the employee fosters and aggravates disharmony in the workplace, that should be treated as a misconduct as opposed to incapacity, because the conduct of the employee is intentional in that particular instance. So one should keep in mind that there are instances where you will find that employees are intentionally fostering disharmony in the workplace, and that would be a form of misconduct as opposed to incapacity. So that's what basically the code has done. Now, this now takes me to my next topic, which is poor performance. And what is new in that regard is that the code adds what it termed as a reasonably achievable standard factor when assessing fairness. And the code basically states that these standards must be realistically attainable within the context of that particular role. The code further confirmed that in some circumstances, an employer need not issue a pre-dismissal warning, meaning you need not tell an employee that if you do not improve in your performance, that will land in a dismissal. And particularly that relates to senior employees. So that same sentiment, what has been echoed by case law before, and one can think of the case of Somio versus Ross Poultry Breeders, which is a labor appeals court judgment of 1997, in which case it determined that in some circumstances, an employer need not issue a pre-dismissal warning, meaning that the employer may deviate from the normal appraisal steps, which leads to a dismissal on grounds of poor performance. And particularly in the following two scenarios in that case it held, dealing with senior employees, and the rationale there was that senior employees are sufficiently experienced to self-assess compliance and should be able to be in a position to know whether they are performing to the standard or they not. And then the second category related to jobs which require a very high degree of professional standards, where even a small deviation could be disastrous for that particular employer. So those exceptions were already there by virtue of case law, but what the code has done, it has basically codified it now in terms of the code. So basically, in a nutshell, the code is basically aligned to what case law has been saying all along. And I think it's a great development, and it brings certainty in terms of what is expected from an incompatibility perspective and from a poor performance perspective. So now employers should know what is expected of them, and it basically cuts away the debate whether or not incompatibility is a form of incapacity, which debate has been settled by case law, but one could say because it was not expressly provided for in the code, one could still want to argue otherwise. But I think this puts the argument to rest. So basically, that's the essence of what I wanted to take you through in terms of incompatibility and poor performance. I will hand over to my colleague, and Anli, I think she'll be dealing with the issue of probation. Thank you.
Thank you, Thabang. So I think on the incompatibility aspect, what's interesting for me there is proving, right, the person who is responsible for the relationships deteriorating and the level of evidence that you will require for that. That's always a difficult consideration. But that's definitely the most prevalent development in this code, that it's introduced incompatibility, and over and above that, to tie into Imran's presentation, the development about accepting that we need nothing further than dialogue and an opportunity for reflection, and also an opportunity to make representations. Now, the reason that's important is it goes to some of the questions that have been asked in the chat already about cross-examination, for example. The Schedule 8 to the code, which this code has replaced, the previous Schedule 8 did not require cross-examination or charges or formalities. All of those have been introduced by practitioners over time. And when I say didn't require charges, I mean the word charges is something that we as practitioners introduced, where you can just call it allegations. It also never required someone to plead guilty or not guilty. None of those things have ever been a requirement, and that still remains the case. So this code very much emphasizes that we need to be practical with reference to the size of our workforce, although the code is silent on what constitutes a small employer. And we need to consider what we can and can't do within our specific organization, with the principles of fairness in mind, or in the back of our minds in undertaking that. And ensuring that by the end of the process, the individual had the opportunity to respond, and they knew what the allegations were against them, and they could properly consider those allegations and give us their representations before a decision has been made. And then obviously, as Imran has said, those representations can be in writing. That brings us to the last two topics, being probation. So the changes in probation are minor. I think the reason I do want to highlight it, it is something that I feel often employers don't use adequately. So to restate the basic principles, probation is basically the period at the commencement of your employment during which your employer is entitled to assess your suitability for continued employment. Now, why probation is so important and why we are great advocates for probation is because you are entitled to dismiss someone for reasons less compelling during the probation period. It means your threshold of what you would need to show in order to prove the fairness of the dismissal is lower for that period because someone was at the beginning of their employment. And that's why it's so important to use that period effectively and to engage with your employees on probation to ensure that they have what they need. Now, you can distinguish between your senior and your junior resources. For junior resources, you may want to check in on what training they may need, what resources they need from you in order to perform their jobs adequately and check in with them. Whereas your senior resources or your senior executives, for example, the law is very clear that they should know what is expected of them. And I think in very few instances can an executive allege that they haven't been properly trained for a job. During probation, what's also important is go and look at CVs and job applications. What are the representations someone made in applying for a job, and use that during your probation period as to qualities that they said they had already versus assistance and training and counseling you may be required to give them. You may extend probation period. The code confirms that again, and you need to set a reasonable period up front, and you have to provide reasonable guidance and support and year representations before you extend or you confirm or you dismiss. So again, there must be an opportunity for dialogue and reflection before you make any decisions in relation to probation, including extending it. And we often get asked, how long do you need to set a probation period for? The code confirms that that depends on the nature of the position. So you need to determine what's reasonable. An executive, for example, may have a longer probation period depending on the facts of the matter, whereas a junior resource, you should fairly quickly be able to see whether or not that individual can meet the standard requirements. Similarly, that argument can go the other way, right? You can say for a senior executive, we're relying on the submissions you've made, whereas for a junior resource, we're willing to give you a bit more training and guidance and counseling, but that's a decision you need to make upfront, be that in your policies or your contracts about your probation periods. Then retrenchment. So retrenchment is now governed in this code where it used to be a separate code. I think to me, one of the interesting developments is that the code is no longer talking about operational requirements. It's calling it a retrenchment. That's very much in line with it wanting to be understandable and accessible. And it's added an Annexure A template. That's the most important development for retrenchment. The Annexure A template now needs to accompany your proposed consultation notice, and it's in the form of a table. And the reason that's quite useful is it's easy to read. It doesn't end up being an extensive document with various paragraphs. It's headings to the left, content to the right, and that allows you to structure your discussions and your consultations and for your employees really to understand the information that's been shared with them. That very much ties in with the code wanting to be accessible and understandable. Our final takeaways is match your process to your context and to your size, but always ensure substantive fairness and progressive corrective approaches. So in each instance, look at the facts of the matter, look at the size of the organization or the specific office you're working with, look at the seniority of the individual, and let that guide the formality of your process. You do not require cross-examination and examination in chief and extensive bundles. You require an opportunity for dialogue and reflection and nothing more than that. And you must be comfortable at the end of each process that you have afforded your employees an opportunity to make representations in response to allegations that they understand. So that's also important. They need to know what they are responding to. Simplify your processes, but keep it fair. And ensure that you have documentation supporting all the steps that you've taken. In order to assist you further in your disciplinary processes going forward, as well as your probation processes, your performance processes, and your retrenchment processes, we have prepared a guide. We'll share the link in the chat and also with all the participants at today's webinar. It's an easy guide to follow with a quick summary of the code, together with an infographic, which will hopefully make it easier for you to implement this code internally. We thank you everyone for your time, and I thank you my colleagues Imran and Tabang, and we hope you have a wonderful Thursday.